O Hawaii, Uama, Ea o Kaina, I ka pono, O Hawaii.
Aloha ahi ahi kako, and welcome to another episode of Kanaka Express. Mahalo for letting us into your homes and watching us on your computers tonight. My name is Kale Gumapac, and I will be hosting Kanaka Express today. I'm, again, always excited to bring our episodes to you because the guests that we have tonight will help to clarify um, a lot of legal issues that people have been bringing up and understanding the terminology of uh, the Lorenzo principle and literally what the impacts will be to the Hawaiian Kingdom as well as to all of us. And so in the Lorenzo principle, it started out with the Hawaiian Kingdom v. Biden federal lawsuit, and it's still playing out in the United States District Court for the District of Hawaii, despite the case also being heard by the Ninth Circuit Court of Appeals in San Francisco. What is before the Ninth Circuit are not the two preliminary judgments made by Judge Leslie Kobayashi in Honolulu, but rather the lawful authority of Judge Kobayashi to make the judgments in the first place. The proceedings before the federal court in Honolulu was to get Judge Kobayashi to transform into an Article 2 occupation court, so it would have lawful authority. And in this Article 2 occupation court, they would have to use Hawaiian Kingdom law. Right now, the federal court in Honolulu is operating as an Article 3 court, which is part of a judiciary branch of government under Article 3 of the United States Constitution, using U.S. laws. And Article 2 occupation court is part of the executive branch of government under Article 2 of the United States Constitution, headed by the President and Commander-in-Chief, of which they would be required to use the sovereign country's laws in adjudicating cases. Article 2 occupation courts are federal courts established in territory that is being occupied by the United States, because Article 3 courts operate within the territorial boundaries of the United States and cannot extend beyond those boundaries into a sovereign country of the Hawaiian Kingdom. Okay, so Article 2 occupation courts were established in Germany after the defeat of the Nazi regime, and these courts administered German law and the law of occupation. Now, what started all of this was a landmark decision that came down from the State Court of Appeals back in 1994, if I'm not mistaken. And they said that although it may be argued, as do many Native Hawaiians, that the actions and the declarations of the United States and the state are determinative of the question of continued existence of the kingdom. Those actions and the actions of the various Native Hawaiian groups referred to above, and there are a bunch of groups that were taking this to courts back in 1994. And the actions of the various Native Hawaiian groups illustrate that there is no clear consensus that the kingdom does continue to exist. Consequently, it was incumbent on defendant to present the evidence supporting this claim. And this was the United States versus Anthony Lorenzo. Lorenzo has presented no factual or legal basis for concluding that the kingdom exists as a state, in accordance with recognized attributes of a state sovereign nature. Consequently, his argument that he is subject solely to the kingdom's jurisdiction is without merit, and the lower court correctly exercised this jurisdiction. And this was the decision that was made by the appeals court in the state of Hawaii. And so it's gone beyond that now. And this is very interesting of how it's now playing out. And especially in the current case with the case that we have, Joe Biden versus the Hawaiian Kingdom. And so I'd like to introduce my co-host tonight. And again, my favorite person, because he taught me a lot of things, even though I wasn't a favorite student in his class, but taught me a lot about color, taught me a lot about different things because he is a teacher at Kamehameha schools. And I just wish that I had a teacher like him while I was going to Kamehameha. I'd like to bring on my special host, Kealii, Akina.
Hello, Mike Ako, Nahomakamaka. Welcome back to another episode of Kanaka Express. I think tonight is very interesting. In tonight's topic, in the fact that time for us to unify as a Lahui and to kind of get our jargon and terminology aligned. There are many groups out there fighting for different aspects of our Lahui, and so it'd be great if our Lahui continues to unify and understands these principles, because it seems as if these principles, if we're all on the same page, it doesn't matter what anybody else says. So if we can get our ducks in a row and be unified and understand some of these principles, and not just the lawyers and the people in the fight, but even the cattle farmer understanding these principles will all help our Lahui to unify and to actually move forward together. So I'm super excited about that, especially since we've heard this Lorenzo verdict in different ways, and so to actually see how it's viewed through international law and how it can impact the U.S. law and ultimately bring back Hawaiian Kingdom law, I think it's pretty exciting. So yeah, welcome back.
Well, I think what you just said about people understanding different things, it was very obvious in the decision made by the appeals court in the state of Hawaii that all different groups at that time were claiming, sovereignty, but nobody had a consensus of what that meant, and so, but today we have we've focused in, and we're sharply knowing what Hawaiian Kingdom and sovereign independence means.
Yeah, I
By
think
by
I think to add to that, Kale, I really believe like our people at the time, many of them are still around who are in that fight and who are pushing different agendas at the time in the 90s.
Yeah,
Super needed, super important. But I could
yeah,
say I feel like maybe they didn't have all the information that's available to us, to the Lahui today. I mean, all the information that's available to the Lahui today, they didn't have it when they were doing their movement.
yes,
And so I think that getting this extra knowledge and extra ike will even enhance or possibly, bring new light to old terminologies, but also bring new understandings. So that's what I'm looking forward to. And I think there are a lot of Kanaka out there that are looking for information. And I think the cool part is bringing in experts to kind of talk about the law and the legal part, because it can be confusing. But if we start to understand it and break it
yes,
down
yes,
together, it'll actually be able to
yeah,
unify all of those different groups who are all fighting for the same thing. We're all yearning for the same, aloha ina. We're all there. So it's a matter of getting us on board, getting them on board, having experts and knowing who is the experts to talk to, and then really understanding the EK and solidifying it in each and every individual Kanaka. So super excited.
and so that's why I'd like to introduce our guest tonight, and he is the Attorney General for the Hawaiian Kingdom, Dexter Kayama, and in talking about this subject, to recognize the impact of the Lorenzo, well, we're going to call it Lorenzo principle, that is coming down from the feds, and explaining just how important that Lorenzo principle is in our the legal arguments that we now take into the court. So, Mahalo for joining us, Attorney General Dexter Kayama.
Aloha.
Aloha mai kākou, aloha Kali, aloha Kealii. I like to think that Kali has many favorite people. And besides Kealii, I would like to think that I'm included in that list of his many.
You're absolutely one of my favorite, right at the top, right at the top.
But no, I appreciate you inviting me on the show tonight. And I'm thankful and honored and with the opportunity to at least present some mana'o on this issue of the Lorenzo principle. Let me first, of course, start by saying that the Lorenzo principle, of course, is a U.S. construct, right? We're talking about it is not determinative of our position as an existing, continuing legal sovereign state. That is separate. The fact that we have been under illegal prolonged occupation is both historically, factually, and legally undisputed. And that we continue as a state under international law is also factually and legally undisputed. What we have, of course, and the reason we're discussing this Lorenzo principle is the fact that many of us are still, well, all of us here in Hawaii are still under the construct of the U.S. occupying power administering U.S. law in violation of Hawaiian Kingdom and international law, when it should be, in fact, administering the laws of the laws of the nation of the Hawaiian Kingdom, the state that is temporarily under prolonged illegal occupation. Real quick comment, Kali, I think when you were reading from that paragraph of Lorenzo talking about that many of Hawaiians, that the actions and declarations of the United States and the state of Hawaii are not determinative of the question of the continued existence of the kingdom. I may have heard you wrong, but I think you left out that word "not," and of course that's entirely important, that it's not determinative. So of course we all know, based on information and the evolution of our education, again, as I said earlier, it's undisputed that we are continuing as a state under international law, independent sovereign state, and that the United States is here illegally under prolonged occupation. The Lorenzo principle, why it becomes important, is that many of our people find themselves at times stuck in a courtroom proceeding in Hawaii, whether it's the state courts, the district courts of the state of Hawaii, or in this case, the U.S. District Court for the District of Hawaii, the federal courts. And what our people are found, what they're required to do is to provide a defense to the complaints that are usually brought against them. Typically, we're talking about either some form of criminal complaint, and in some instances, civil complaints brought against them. And what the individuals, we as individuals, are doing is contesting the very subject matter jurisdiction of the courts, the very authority of the courts that are administering U.S. law, and providing them with both law and information, law that they created. Let me just take a step back. Law that the U.S. courts created in determining whether they have subject matter or personal jurisdiction over the citizens of the nation of Hawaii, or the subject matter complaints that they are meant to deal with. Lorenzo, as Kali spoke about, was a case, State of Hawaii versus Lorenzo, that was issued by the Intermediate Court of Appeals of Hawaii in 1994. Again, Mr. Lorenzo was actually cited for traffic offense, failure to render assistance after a motor vehicle accident, driving without a license, and then negligent injury. In contesting the citations and the complaints brought against him, Mr. Lorenzo argued that he was that this is the Hawaiian Kingdom, not the United States, that he was a citizen of the Hawaiian Kingdom, and because this was the Hawaiian Kingdom, the court had no personal, he was actually talking about personal, but I also think he intended to argue or assert that it had no subject matter jurisdiction over him. The lower courts, of course, ignored Mr. Lorenzo's argument and found him guilty of the offenses I spoke of earlier. Mr. Lorenzo then took it up on appeal with the Intermediate Court of Appeals, asserting the same legal arguments. That's where Kealii spoke about the idea that Lorenzo, at that time, the Lorenzo court made a determination that the burden was on Mr. Lorenzo himself to provide facts and evidence, for concluding that the Hawaiian Kingdom continued to exist as a state in accordance with the recognized attributes of a state's sovereign nature. Again, it was the Intermediate Court of Appeals determination that Mr. Lorenzo failed to provide those facts and evidence. And as such, because he failed to provide those facts and evidence, his appeal was, of course, denied, and the lower court's decision against him was affirmed. I think Dr. Sai has written about this subject on a number of occasions, and I think the idea, the evolution of Lorenzo principle has been provided in both the Hawaiian Kingdom blog as well as a number of writings by Dr. Sai. But if I may, I'll speak to it in a little bit. But before I do, I just want to find out if either of you had any questions or comments before I continue.
Well, I think for me, it's just really interesting that the number of people that the decisions on the lower court affected. I think there were over 90 cases throughout the years since 1994 that people went into the courts saying that the courts have no jurisdiction, and every one of those cases, the courts ruled against them using the Lorenzo case as, from the Court of Appeals as a reason to deny and dismiss the case. And so, now, well, just continue with what you're going to be saying, because I just wanted to point that out.
Okay, and so I'll continue. So the first, how can I say, iteration of the Lorenzo doctrine was that we believe was that the burden was on the defendants in the cases to provide facts and evidence to conclude that the Hawaiian Kingdom continued to exist. And for a number of years, as you spoke about Kealii, I do believe many of the defendants brought into court did provide both the facts and evidence to conclude that the Hawaiian Kingdom continued to exist with the attributes of a state sovereign nature. But because this is, of course, a U.S. construct, and it is administering the laws of the occupier instead of the laws of the occupied nation, it was simple during all these years for these courts to ignore and dismiss the facts and evidence that was being submitted to the courts to meet the burden of Lorenzo. I think I've had personal experience. I believe, Kealii, you were in front of those arguments, and some of those arguments where I believe we provided undisputed facts and evidence to conclude that the Hawaiian Kingdom continued to exist, and the courts continued to ignore the meeting of those requirements and continue to hold in favor of either state actions or civil actions against citizens wishing to contest the jurisdiction of the courts. Before I continue, let me also, since we're talking a little bit about it, let me give you a brief update into the U.S. District Court case in the Hawaiian Kingdom versus Biden. And I'll speak real briefly, but no need to speak too much about the appeal from the U.S. District Court decisions to the Ninth Circuit Court of Appeals. A couple interesting, or I guess important dates to mention to our viewing public. On March 30th of this year, the court issued an order granting in part and denying in part defendant Anders Neville's motion to dismiss the amended complaint against him. The Hawaiian Kingdom brought an amended complaint against Mr. Neville's in his official capacity as a counsel for the Swedish government and the consulate here in Hawaii. Our claim against Mr. Neville's and a number of the foreign consulates and counsel was that they were here in violation of Hawaiian Kingdom and international law because their presence in Hawaii was a result of permissions, or what we call executors, that were received by the U.S. State Department. That is, again, the administration of U.S. law, and not from the Hawaiian Kingdom government, which was required, as this is the law of the sovereign nation. So we said that their presence here was in violation of international and Hawaiian Kingdom law. Mr. Nevels brought a motion to dismiss before the U.S. District Court of Hawaii, saying that in my official capacity as the Swedish consulate, I'm immune from prosecution, or the courts have no jurisdiction over me, which is interesting. The U.S. District Court for the District of Hawaii has no jurisdiction over the complaint against him, because he is Swedish consulate that's protected by the Vienna Convention, providing immunity for foreign consulates. Because the U.S. again continues to, how can I say, the U.S. courts, the Hawaii District Court for the District of Hawaii, U.S. District Court for the District of Hawaii, continues to foster the fallacy of its authority to operate as an Article III court within the territory of the Hawaiian Kingdom, and continues to administer U.S. law, as opposed to the correct application of Hawaiian Kingdom law. It did rule that Mr. Nevels, of course, was not subject to the U.S. District Court's jurisdiction, because he is a Swedish consular protected by the Vienna Convention. In the complaint also, or in the order granting and denying Mr. Nevels' motion to dismiss, the U.S. District Court incorrectly relied on a case called U.S. Bank versus Fonoti. And in the U.S. Bank versus Fonoti, in that court incorrectly ruled there is no factual or legal basis for concluding that the Hawaiian Kingdom exists as a state in accordance with the state's sovereign nature. It was incorrect because it misread and misapplied the Lorenzo case, where Lorenzo, of course, said presently there were no facts. So what it did is Lorenzo created a burden for any defendant to provide facts and evidence to conclude that the Hawaiian Kingdom did continue to exist. The U.S. District Court of Hawaii misapplied using U.S. Bank versus Fonoti to basically make it a conclusion that the Hawaiian Kingdom no longer exists, and this how can I say, dismiss or do away with that burden of proof that was created by Lorenzo, and they did so incorrectly, and we would say erroneously. It also denied the Hawaiian Kingdom's amended complaint that the court, the U.S. District Court of Hawaii, transformed itself into an Article II court, as Kealii said, an occupation court, because of course the Hawaiian Kingdom is under illegal prolonged occupation, and not a civil court created by extrajudicial legislation of the United States Congress. It denied Hawaiian Kingdom's first amended complaint requesting transformation into an Article II court because it erroneously relied on and stated the U.S. Bank versus Fonoti ruling. Thereafter, the following day, the Hawaii District Court, U.S. District Court for Hawaii, also issued an order denying the Hawaiian Kingdom's request for judicial notice regarding civil law on juridical fact of the Hawaiian state and the consequential juridical act by the Permanent Court of Arbitration. I know we've spoken about that before, and Dr. Sai has explained it to our viewers and in his writings, both on the blog and other writings. That recent information, including the testimony of Dr. Federico Lorenzo, Lenzarini, Lorenzo Lenzarini, forgive me. Lenzarini spoke about the fact that most of the rest of the world is a civil law systems as opposed to the common law and judicial acts and judicial case precedents by the courts that's recognized in the United States. And under civil law, the juridical act of juridical fact of the Hawaiian state. And they've talked about the fact that the Hawaiian state was recognized as an independent nation beginning in 1843 and recognized by treaties between the Hawaiian Kingdom and many of the countries, and once again recognized by the Permanent Court of Arbitration in the Larson versus Hawaiian Kingdom case. That juridical fact resulting in the consequences of the Permanent Court of Arbitration basically acknowledging, by acknowledging the Hawaiian Kingdom existed as a state, as an independent state back in 1843, it changed the civil law view of the Hawaiian Kingdom. And my best way of explaining that is that now there was a presumption of the continued existence of the Hawaiian Kingdom, only to be rebutted by evidence that would show that existence was in fact extinguished. And as all of our viewers know, there has been no evidence provided whatsoever, no factual or no legal evidence to show that the existence of the Hawaiian Kingdom has ever been extinguished once it was legally recognized and factually recognized in 1843. However, the U.S. District Court for the District Court of Hawaii denied the Hawaiian Kingdom's request for judicial notice of the juridical fact and the juridical act. It once again incorrectly relied on U.S. Bank versus Fonoti and misapplied the Lorenzo principle, as we know. Real quickly, in April, let's see, shortly after, within 2 weeks, the Hawaiian Kingdom filed its motion to alter and amend the court's ruling in both the granting of Nervale's motion to dismiss, as well as the denial of the Hawaiian Kingdom's motion to request a judicial notice of the juridical act and the juridical fact. Sometimes get that reversed. The juridical fact of the Hawaiian Kingdom and the juridical act of the Permanent Court of Arbitration. Excuse me. Basically, at that time, when filing of our motion to alter and amend, we pointed out to the court that its reliance on U.S. Bank versus Fonoti was in error, and that it erroneously misread Lorenzo, and to the exclusion of Lorenzo's holding that presently, there is no factual legal basis for concluding that the Hawaiian Kingdom exists as a state in accordance with the recognized attributes of a state's sovereign nature. We also pointed out in that motion that the Lorenzo principle, or the Lorenzo rationale, that is the ruling in the state of Hawaii versus Lorenzo, the court itself said it, the appellate court, that its rationale was open to question in light of international law. In our motion to alter and amend, we basically asserted the shifting of the burden of proof, not from the defendants, not from you and I, to provide factual evidence to conclude that the Hawaiian Kingdom continue to exist, but in fact, the presumption of the continuity of the Hawaiian Kingdom. And that, and at the same time, in that motion, still providing the evidence in support of the presumption. And then asserting that once provided with that minimum evidence, and that's what we're saying, that the burden shifted to Nervale and to the court to provide facts and evidence to rebut the presumption, of the Hawaiian Kingdom's continued existence as a state. Thereafter, a week later, the court denied our motion to alter and amend. And we followed that up within a week by filing our notice of appeal to the U.S. Court of Appeals in the Ninth Circuit. Now, at the time, we filed our notice of appeal with the U.S. District Court in the District of Hawaii. And then when we filed our appeal, that was April 22nd, we noticed in our appeal that we were filing the appeal to a court of competent jurisdiction, that is an Article II occupation court, herein to be established by the U.S. as the occupying power. Real briefly, shortly thereafter, the U.S. Court of Appeals for the Ninth Circuit, what's the correct word? They assigned the case to the U.S. Court of Appeals for the Ninth Circuit, again, an Article 3 court, not an Article 2 court as requested by our notice of appeal. And that's another matter, and that's a matter that we eventually, in the U.S. Court of Appeals, filed a motion to let the U.S. Court of Appeals know that it could not, in fact, address our appeal so long as it was or continues to be an Article 3 court and not a court of competent jurisdiction that is an Article 2 court. Most recently, on June 6th of this year, the court filed an order granting the federal defendants, and that is the U.S. defendants in Hawaiian Kingdom versus Biden, including President Joseph Biden and the other U.S. defendants. The court granted the federal defendants cross motion to dismiss the first amended complaint against them, continuing its erroneous reliance on U.S. Bank versus Fonoti. And at the same time, and it's another issue, but not an issue for the discussion tonight, it did also invoke the political question principle to hold that determination as to who is the sovereign is a political question. The determination by the legislative and executive departments, which exclusively binds the judges. It was a secondary way, of course, of trying to deflect from their obligation under international and Hawaiian Kingdom law, them being, and I'm talking about the U.S. District Court for the District of Hawaii, that office or that judicial department being located within the territory of the Hawaiian Kingdom. Finally, on June 15th of this year, the Hawaiian Kingdom filed its motion to alter and amend the court's order granting the federal defendants motion to dismiss. At that time, and that's where I think the Hawaiian Kingdom articulated the Lorenzo principle and how the court was under an obligation because of the Lorenzo principle to overturn, alter, or amend its decision in granting the federal defendants motion to dismiss the Hawaiian Kingdom's first amended complaint against them. That was a lot said. Before I go forward, can I ask you guys if you have any comments, any questions about that, and give me a chance to catch my breath.
Well, the question that I have, again, is, I guess what under federal law, what is so important about making the determination of the Lorenzo principle? And and I'm not sure if you're getting to that point, but the importance and what does that mean?
Okay, I don't know if I got to that point either, but I think I'll try to get there. Okay, so previously in previous iterations, when we attempted to assert the holding of the Lorenzo principle or the case of Lorenzo, and this is part of our evolution, we took it to mean that the burden was on us as the defendants, and us meaning generally any defendant that was brought into a U.S. court by way of complaint, civil or criminal, and that burden was on the defendant to provide facts and evidence in order to question whether to determine that the court did not have either subject matter or personal jurisdiction over the complaint or over the person in the case. And that is by asserting that that person normally was a citizen or a Hawaiian national, and that the complaint brought against him was a complaint that was brought under U.S. law, not one that was brought under Hawaiian Kingdom law. So that generally was our first evolution, was that placing that burden on us to provide that facts and evidence. Later iterations and the evolution of the case and the argument was that, and with the assistance, of course, as you can see in the federal cases with the filing of the amicus brief by the National Lawyers Guild and the International Democratic Association of Lawyers, as well as the Water Protective Legal Collective, as well as the testimony of Dr. Federico Lanzarini. And as you can see from our motions as well, we also cited to the writings of Professor Crawford, who is now one of the sitting judges with the International Court of Justice, as well as the writings of scholar and Professor Matthew Craven. We've come to a better understanding and an evolved understanding. And the clear words of Lorenzo itself, that that burden, in fact, has always been and should have always been the primary burden, should have always rested with the party, in this case, whether it's the United States, state of Hawaii, or any individual asserting a claim against the defendant, that the ultimate burden lay upon them to provide facts and evidence, and what we call rebuttable facts and evidence, that the presumption of the Hawaiian Kingdom continuity was in fact extinguished. In my mind, I think whenever a defendant is brought into litigation within the U.S. construct, the U.S. judicial system, I think it still requires a minimal assertion of the existence of the Hawaiian Kingdom. But once that minimal assertion is presented, then the burden shifts, and then that burden becomes fully laid upon, again, the party bringing the action, whether state, U.S., against that individual, to show that that continuity was in fact extinguished. Failing to do that, it should be the legal obligation of the courts to dismiss that complaint for lack of subject matter jurisdiction or lack of personal jurisdiction, as asserted by the defendant. Kealii, does that answer your question, or is there more that you?
Yeah, that sort of answers the question. But is there a federal statute that says that an existing state, foreign country, does not have to prove of its existence? And so, because the arguments that that many of the Hawaiian Kingdom subjects were making was that the U.S. had no jurisdiction in this matter, and then they would lose the case because we did not provide evidence of the Hawaiian Kingdom in existence. So once that was proven, things reversed. So what caused that? I mean, is there a federal statute, federal law, or whatever that sets it up for that?
Okay. I'm not sure I know what you're referring to. Do you have anything in mind that you're referring to? Because again, it is the case itself. It is the case itself that provides the so to speak roadmap.
Well, what constitutes the Lorenzo principle for us to now say that you, the feds, have got to prove that the Hawaiian Kingdom doesn't exist?
Well, so what it was is that the Lorenzo doctrine, in first initiated versus state versus Lorenzo, was a case that was relied on by subsequent courts in the denial of argument by defendants wishing to maintain and assert that that they are either Hawaiian nationals or that they are in the Hawaiian Kingdom, and that therefore that the courts, the American courts, that is state of Hawaii or federal courts, have no jurisdiction over them. And it was born from Lorenzo. It was born, if I may say. So what happens is that when the courts, whether in state courts or in federal courts, they continue to rely on that ruling in state of Hawaii versus Lorenzo, establishing case precedent. And is that case precedent, in fact, it was the case of, what is that case? Excuse me. One of the cases in the Ninth Circuit, U.S. versus Gu, where they coined that phrase, the Lorenzo principle. Again, it it cited the Lorenzo case. It talked about the requirement for providing facts and evidence to conclude that the Hawaiian Kingdom continued to exist with the attributes of a state sovereign nature, and defendants continuing to fail to provide or meet that requisite burden of proof. And so it was the Court of United States versus Gu that basically said that we're going to continue to rely on Lorenzo, and henceforth this would be called the Lorenzo principle. So I think that's what you're referring to.
Yeah, I'm referring to the understanding of presumption.
Right. So it is by a judicial precedent that burden of presumption was initially articulated by the court in Lorenzo. And I would say the best way to perhaps say it now is that with the additional information and a better understanding of Lorenzo and a complete reading of Lorenzo, we can now make the argument that Lorenzo itself says that the burden should have always been on the party initiating the complaint. And the reason we can point to that is that the court in Lorenzo itself said, and let me see if I can find the exact words, that the Lorenzo says, although the court's rationale is open to question in light of international law, the record indicates that the decision was correct because Lorenzo did not meet the burden of proving his defense of lack of jurisdiction. Okay, now that phrase there, that the court's rationale in Lorenzo is open to international law, is significant. Because international law, and that's why we set forth in our motion to alter and amend before the U.S. District Court of Hawaii, international law is different than the law that is currently operated under the administration of U.S. law. That under international law, once the existence of a state comes into being, and we do know there's undisputed that the Hawaii state came into being with the initial issuance of the Anglo-Franco Proclamation in 1843. Once existence occurs and recognition of that existence occurs, then that existence cannot be extinguished other by a treaty of concession, or what they call by war or debelasho. And we also know that under international law, the U.S. has failed to meet either of those requirements. So it is a better understanding of Lorenzo that has resulted in the evolution of our argument, placing that burden now, in this case in Hawaiian Kingdom versus Biden, on the defendants, that being the Swedish consul, Anders Neville, on the federal U.S. defendants, including President Biden, as well as the court, and that being Judge Kobayashi, who issued the decisions we believe in error of the Lorenzo principle.
So do you believe that the Permanent Court of Arbitration that the Hawaiian Kingdom entered into, and the Permanent Court of Arbitration's recognition of the Hawaiian Kingdom as being in continuity had obviously had a major impact on the Lorenzo principle, because it establishes that the Hawaiian Kingdom is in continued existence? And so under international law, am I correct that the United States is now they are now the ones to prove that the Hawaiian Kingdom doesn't exist as a result of international law?
Well, again, and that's why I think my initial comments early on was that what we're talking about is completely separate from the political and legal status of the Hawaiian Kingdom. That what we're talking about when we talk about the Lorenzo principle is the fact that we are stuck in a U.S. construct, and that being the U.S. judicial system, whereby we are forced to operate and oftentimes defend against claims against us from either State departments, U.S. departments, individuals seeking to claim relief against defendants such as myself, such as yourself, based on the administration of U.S. law. So it is completely separate from the legal status of the Hawaiian Kingdom. But many of us are forced into that U.S. construct because that is the system, the judicial system that currently operates within the territory of the Hawaiian Kingdom. So having been forced into that U.S. judicial construct, their own law, and that being the case of Lorenzo, not only opened the door, but as written by Dr. Sai and argued by the Hawaiian Kingdom, in fact, they have effectively placed the nail in their own coffin if they are, in fact, if they are compelled by their obligation to follow their laws and act in contemplation of law. Another thing, the reason why the Permanent Court of Arbitration, I would say, perhaps did not have so much of an impact on the Lorenzo case, but in fact provided that support for argument under the Lorenzo principle, is, as we all know, the case of Larson versus the Hawaiian Kingdom occurred, I think, in the period between 1999 and 2001. And the Lorenzo case initially was decided in 1994, so it predeceased. I mean, not predeceased. It occurred prior to the actual arbitration proceedings in Larson. But the Larson court, in acknowledging the existence of the Hawaiian state in 1843, was consistent with international law that basically held, once that existence is acknowledged, it is upon the party wishing to extinguish that existence, it's that burden of that party wishing to extinguish that existence to provide the proof and evidence that that existence, in fact, was extinguished. And as we all know, and what is true, is that there has been no such evidence that has been, and I would assert that can ever be provided, that existence of the Hawaii state has ever been extinguished, except by virtue of the illegal prolonged occupation by the United States.
Kealii, any questions?
I don't think I have questions. I just kind of like thinking in my mind. So the main things that I think I want to understand is, one, the burden to prove that the Hawaiian state was extinguished is no longer on us, but on them. And then two, that when we're talking about this principle, it's not necessarily connected to the status of the Hawaiian Kingdom. It's just the way the U.S. looks at it. And I guess something that kind of confuses me is, and I think about this whole process as far as, I think it was what Kale was trying to get to or talk about. What it was like, who is forcing or enforcing or making the courts look at the principle from this different or the opposite view. You know what I mean? Like, what's gonna compel them to look at it now from this international lens versus continue on and looking at it the way they've always done?
Okay, couple of good questions. I'm not sure I have all the answers, but let me offer some. So first, of course, what we're doing, and the first party that I would say that is making those assertions and attempting to hold the courts here in Hawaii, including the U.S. District Court of Hawaii, to their legal obligation, of course, is the Hawaiian Kingdom by virtue of its complaint against President Joseph Biden and a number, in excess of 30 additional defendants, including the state of Hawaii and a number of agencies, including foreign consulates that are, how can I say, residing presently in Hawaiian territory under permission from the United States and not from the Hawaiian Kingdom. So I think we are attempting to hold the U.S. District Court for the District of Hawaii to its legal obligation to correctly read and apply the Lorenzo principle. And once it does correctly apply the Lorenzo principle, to make a determination that that the defendants in these cases, the federal defendants, Defendant Nerville, and all the other defendants have an obligation, the court included, to provide rebuttable or factual evidence to conclude that the Hawaiian Kingdom was in fact extinguished. It's our position that once the shifting of that burden is acknowledged, and the legal obligations of the shifting of that burden is acknowledged. And by the district court, I think it is our hope that it changes the paradigm of judicial proceedings here in Hawaii, both in state and federal court. Of course, we also have how might I say, there's a larger goal with the Hawaiian Kingdom complaints and proceedings, is that it's our continued obligation to, in the education and the evolution of that information that's disseminated not only locally but globally, with the intention of compelling compliance with international law and no longer recognizing the illegal prolonged occupation of the United States, and eventually leading to a peaceful transition and deoccupation by the United States back to the Hawaiian Kingdom and the Hawaiian Kingdom government. Kealii, I think in some of your initial comments, I think I agree with what you said about our people back in the 1990s, and part of Kealii's comments about the non-consensus of the Hawaiian nationals at that time. I agree completely that there's been additional information that I think impacts the position that should be taken. I think is one that is based on both undisputed fact and law, and as well as support by international law. So I think there is a legal and factual consensus as to the status of the Hawaiian Kingdom, one that perhaps was not as well known, not that it didn't exist because that always existed, but one that was not either well known or not articulated by the court in the Lorenzo case. I also think that time in the 90s, there was perhaps more a consciousness of Hawaiian as indigenous people of the United States. One that was a result of, how can I say, a U.S. propaganda and the inculcation and the misinformation that was provided or disseminated by the United States to change the way of thinking of our people. And since the 1990s, with the exposure of the additional information, I think that mindset and that thought process has changed tremendously. I think it becomes more of a normalized language to be talking about the illegal prolonged occupation and our status as an independent state, our status meaning the Hawaiian Kingdom's status as an independent state. So I think the idea of, or the concept of changing the court's view of the Lorenzo principle, within the U.S. construct, forces the courts, forces the parties to recognize what is undeniable. And what is undeniable? That this is the Kingdom of Hawaii continuing as a state under international law, and that all parties here should be administering Hawaiian Kingdom and not a U.S. law. And I think we continue to move toward that direction. Sometimes lose my train of thought, so I'll stop there, see if we have any other questions or comments.
Yes, for Hawaiian Kingdom subjects that are going into courts today, let's say for foreclosure, and they refuse to leave their properties and so forth and get arrested for criminal trespass. I'll use myself. Now, how important is it in using the Lorenzo principle in this argument for Hawaiian Kingdom subjects that would be going into court, or would it? what?
So let me just answer it in a more general. Doesn't
Okay.
necessarily have to be addressed to any particular topic, but let me answer it in terms of a general. Should a defendant be brought, a defendant who asserts that he is either a Hawaiian national, a Hawaiian citizen, or just argues that because he's within the territory of the Hawaiian Kingdom, that it is Hawaiian Kingdom law and not U.S. law which should apply, and that the application of U.S. law um, basically eradicates the judicial court's jurisdiction over the complaint over the person that's being brought before the courts in Hawaii under U.S. law. Um, again, I guess my comment and my suggestion is that any Hawaiian national citizen, Hawaiian national, should make the argument that the Lorenzo principle. First, I do believe that there is an initial burden to provide at least the foundational evidence of the Hawaiians' existence as a state recognized in 1843, whether that be the Anglo-Franco Proclamation or other documents, to at least introduce the evidence of the Hawaiian Kingdom's recognition as an independent state. Once that's done, then the burden shifts to the defendants to prove that the existence has been in fact extinguished. So I think it is my opinion and recommendation that any citizen or any person wishing to contest the jurisdiction of U.S. administered courts should make that argument. But as we know, Kealii, as you know from firsthand experience, what has happened is that the courts, though we continue to change the ground under them, what they do is in fact change the rules by which they operate. And what they can do and have done for a long time is first ignore the fact that defendants were providing facts and evidence to conclude that the Hawaiian Kingdom continues to exist as a state in accordance with states' recognized nature. And now I do believe that the correct application of the Lorenzo principle may still result in the courts ignoring the shifting of the burden. And should that happen, and in all likelihood that will happen or continue to happen, at least for the time being, that defendants may still, by necessity, be required to avail themselves of laws under the U.S. and U.S. laws in order to either prevent their prosecution in criminal cases or to obtain any kind of court relief, so long as it's a court that administers U.S. law.
So some of the problems, well, not some, a huge, I guess, void, here in Hawaii is getting attorneys to represent, clients in this case. What is being done to get more attorneys on board, that you may know of, or what's your view on that?
Hard for me to comment because I've been involved in this for a number of years now, and it is kind of a solitary adventure in many respects. But I do believe that attorneys are more aware. But then taking the next step to actually take the position on behalf of clients is a step that they still require assistance. I don't know how else to explain it, but there are consequences to taking this position, to taking a legal position such as this, and all I can say is perhaps up to this point, perhaps people have refrained from making those arguments and facing those possible consequences. So I do know, for example, with the National Lawyers Guild, and to the international lawyers and the International Association of Democratic Lawyers and the Water Protectors Legal Collective. Those are significant, favorable changes. I think the opinions of organizations and entities that are renowned, that in fact have both access and perhaps consultative status with the United Nations, I think that changes things. I think that lawyers here in Hawaii, there are a few lawyers that are taking steps in support of those kinds of briefs and legal positions. I just can't. I don't know that I can answer your question, Kealii, as far as the recruitment of other attorneys to make these arguments. I'm sorry. I just don't. I mean, I do know that a number of our Kanaka, yourself including Kealii, and I've seen a number of people who responded on the Hawaiian Kingdom blog. They seem to be pretty well educated about the ideas, and perhaps, if required, could easily make a number of these legal arguments as themselves on a pro se basis. And just like Lorenzo made that argument without legal counsel, that with the correct information, that legal argument can be made, and the assertion of the Lorenzo principle shifting the burden can also be made. So without legal representation. Now, depending on the complaint or the situation that the defendant is brought in, he may need to, if the argument challenging jurisdiction is denied, although incorrect by the court and in error, that defendant may then seek legal counsel to avail themselves of defenses or remedies that might be available currently under U.S. law.
Well, if I could make a comment, then again, as a result of experience, on this, is that the attorneys that initially said that they were very interested in taking cases in regards to the Hawaiian Kingdom ended up tucked tail and they ran after they got involved in the case initially, and literally they panicked and ran and dropped the cases, and primarily they were afraid of repercussions coming from the state of Hawaii, the United States, and so forth. And this is my experience with the attorneys, and I was hoping that at some point in time, Aloha Aina attorneys, patriotic attorneys, would step up, like yourself, Dexter, to do the right thing for our people. And unfortunately, these attorneys have not done that. Whether they're sold as being United States attorneys and so afraid of losing their practice or whatever it may be, rather than doing the right thing. So it's just a comment on my part.
And if I may, I think the numbers are still small, but there are a few attorneys who have made the argument, who have taken a legal position in support of the continued existence of the Hawaiian Kingdom on behalf of their clients. So there are some. And I know a few of them by name. And I don't know if now's the time to name them, but if I might just make one comment about a colleague, Steve Loddick, who passed away in June of this year. Steve Loddick was I have to say, he was a firm and solid advocate for the Hawaiian Kingdom. And he was one of those attorneys who would be willing to make those arguments on behalf of his clients. Unfortunately, his untimely passing in June leaves our country devoid of one attorney who was willing to provide that kind of help.
Yeah, and I'm very sorry to hear about that. And again, Steve, you're right. Steve was a strong advocate for people in the Hawaiian Kingdom and the legal arguments that needed to be made in the courts. Kealii, any thoughts?
Um, well, I think about Steve. One thing is that I want people to know too is that he wasn't a Kanaka. You know what I mean? But he loved this place. He loved this Aina. So you know what I mean. So we're not calling all people. The Hawaiian Kingdom is not a race-based type of place, right? It's an aloha-based place, and I think people like Steve actually embodied that with all his wit and sarcasm. He definitely embodied that aloha Aina spirit as well, even though his so-called ethnicity was not Hawaiian. I believe he weren't under occupation. He definitely have applied and would have been a Hawaiian. So super cool to think about him. But I also think about, I guess, kind of an offshoot of what you guys are talking about. It's not the lawyers that are already lawyers that I'm looking at. I'm looking at these young guys who are in law school right now. You know what I mean? Who've been through these classes and understand occupation and these paces of our people, and now they're becoming lawyers. Where who do they go to for the mentorship? I guess as far as learning, Hawaiian Kingdom law and those types of principles, because there are a lot of young people who are interested, you know what I mean? But when they go into law, they go away or they go someplace else, and all they learn is American law, U.S. law. So where's that? I mean, I don't know the answer. There's no like, where do they go to learn about the Hawaiian Kingdom law so that they can make these arguments? Because basically they're learning about U.S. law as a Hawaiian national, trying to make an argument for a system that gave them the authority to practice law. So it's kind of a catch-22 for them and for you, Dex. But let me just think about that. Like, where do they go? Like, what's the place? Like, do we send them to Oxford to learn and become a lawyer and then come back to Hawaii? Because everything here is U.S. And I feel like that's a hard part for them because a lot of them are interested in serving and fighting and servicing the lahui, but when they get there, there's no information about that.
Well, unfortunately, making that argument and having that as a profession here in Hawaii is not sound financial planning at this time for an attorney. There's no, how could I say, market or something that a person can perhaps have a viable and perhaps, well-funded legal career by making this argument. So that at this point doesn't exist. Now, I do know that you can continue to practice law in Hawaii, and perhaps that's where joining something like the National Lawyers Guild and it's part of their committees and the International Association of Democratic Lawyers, as well as the Water Protective Legal Collective. Now, those are organizations that's outside of Hawaii, but what they have to their benefit is that they're not burdened by the, what can I say, burdened by the entrapments of having to live here in the state and having to deal with the political issues that surround political and associated with that economic issues. Those kinds of lawyers guilds and those kinds of entities are free to examine situations in law based on the facts of the case and are not burdened by those political or economic trappings or social trappings. So I would probably suggest to people here in Hawaii to continue that have an interest in law, perhaps to look in law and maybe for now, for the time being, to work in areas of law that provide for you and for them and their families. But then to join these kinds of organizations to get a broader idea of what the legal arguments might be here in Hawaii. And perhaps in different situations, they might be able to assert it, perhaps in small ways, but that's where it starts. If they're able to assert it or to at least have that different consciousness, I think that's a start. Because to have that different consciousness then can lead you. It's my belief entirely that when it's difficult not to do the right thing, And so once you become aware, whether it's through other organizations, that at some point I think you come to that crossroad where you can't avoid doing the right thing. And in this case, the right thing is that the Hawaiian Kingdom continues to exist as a state under international law, and that the administration of Hawaiian Kingdom law should be applied here in Hawaii, and not the administration of U.S. law.
Is there a way that we can, go to the, I guess it's the Richardson School of Law, to get them start to add into their curriculum the teachings of Hawaiian Kingdom constitutional law.
Well, it's possible, but I can tell you that, a few years back, I don't remember the number of years ago, but somewhere around, and forgive me, about 4 or 5 years, I think we did, with the assistance of Dr. Professor Chang, I can't remember his first name, Bill Chang. He was willing to create a curriculum in the law school that talked about Hawaiian Kingdom law, and in fact had invited both Dr. Sai and myself to speak in his classes about that. But his class and that curriculum met with resistance from the law school, and because of that, we weren't able to continue because of that resistance. Now, I do think that with the passage of time, things may change, and those kinds of things are possible. So,
well, in situations like that, I think the more we start, I guess, making noise, the squeaky wheel always gets the grease, and this is what happened, up on Mauna Kea, with finally getting UH out of there, and until we start, we have to help all of our young Aloha Aina people coming up that are patriots, that are wanting to do good work for the Hawaiian Kingdom. And we cannot just write it off and say, oh, well, we don't have any program. Let's do something about demanding that the School of Law, Richardson School of Law, and whatever it takes for us to go up there and get them to change that curriculum so that we can begin to have Hawaiian Kingdom attorneys come out of the School of Law without them being, U.S. attorneys and going in thinking that they want to represent the Hawaiian Kingdom, then coming out and only representing the United States. We have to start someplace. And, I don't know,
Kaiyama School of Law.
no, I would say,
absolutely.
correct me if I'm wrong, Kealii, but no Leila, the Kanaka Express.
Okay, so then on Kanaka Express, we're creating crowdfunding for the Kaiyama School of Law.
No, not the Kayama School of Law. I think it just can change from within. But I think it's these kind of programs that have these kinds of discussions that are important. So,
Well, Charles Keoho from Maui wrote a statement in regards to Steve Laudig, and he says that Steve assisted him with writing letters to Secretary Blinken, and Charles appreciate the comment because, again, Steve Laudig was a good guy, and he will be missed, and he did a lot of good things.
yes, I thank you. I agree, and colleague and friend, and I think Steve's like Kealii said, Steve's presence and his advocacy for the Hawaiian Kingdom was consistent with the Hawaiian Kingdom's notion of not about race, but about what you can and how you can produce for your Hawaiian Kingdom. And I think Steve was a testament to that.
Okay, well, I really appreciate you joining us tonight, Dexter, to help to explain the Lorenzo principle, because to me personally, I think that it will have a tremendous impact now, and it'll call to the attention of the courts, when they deny cases and, with Hawaiian Kingdom subjects or people going in and arguing that the Hawaiian Kingdom exists and that the jurisdiction of the courts is unlawful, and using the Lorenzo principle, because we have proven that the Hawaiian Kingdom continues to exist, and we never lost our status as a sovereign, independent country. And now people are stepping up. All they need now are the correct legal arguments to take into the courts, of which you and Dr. Sai, as well as Dr. Federico Lanzarini and the National Lawyers Guild and so forth, is now helping to change and to make huge changes that affects the decisions that will be coming out of both the state as well as federal courts.
Well, thank you for the invitation, Kealii. I hope I was able to provide a reasonable and good explanation of the Lorenzo principle. I gave it my best shot, so I hope that was at least a decent explanation.
Oh, it was great. It was great. And just a side note, Attorney General Dexter Kayama will be coming to Hilo, to Hawaii Island, and they'll be here on Friday. And so for those of you who are listening and can make it, please come and join us, for with questions so that you can ask the Attorney General of the Hawaiian Kingdom the questions directly. So let me know if you're interested. Kealii?
All right, just wrapping up. Mahalo for sharing your your point of view, the terminology. We really appreciate that. And I just think for me, just making everybody understand or kind of thinking last thoughts is it's not our burden to prove that the kingdom exists. It's their burden to show that we don't exist. And so I think if we can start making that our mantra as a lahui, and that becomes second nature, that will give more power to unity and unification of our people, but also bring more light to the law. And again, how do we get, not just the 40,000 Kanaka living in a big island? How do we get everybody in the world to understand that? So we need a whole bunch of social media memes and TikTok things about it, and all these pieces that talk about, hey, it's not about we proving that we exist, it's you proving that we don't exist. And so which is listening out there, come on social media experts and all those media peoples and blue check marks, like, get it out there, Hungry Hawaiian, like, show everybody that, hey, it's up to the burden of them to prove that we don't exist. Yeah. So mahalo again, Dexter. Really appreciate your time.
Final thoughts, Dexter.
No, Kealii has it right on. Right, he hit the nail on the head with that one. I agree entirely. I do believe that consciousness is growing. I do believe that consciousness is spreading, and I do believe that with that increased consciousness, people cannot help but start to act in a pono manner.
Okay, with that said, I'd like to thank all of you that are out there tonight, and we're going to be posting this on YouTube, so that if you did miss this episode, it will be posted on YouTube, and again, you can watch it on Facebook, Aha Kanaka Moko Okeawe's page, and again, a big mahalo to Dexter, because the work that the Attorney General Dexter Kayama and Dr. Keanu Sai has been doing has been tremendous, and especially in the legal arena, that is so important for us to understand. And I hope for those of you out there that are watching this episode, that you learn the correct laws that are coming out, and you also learn the importance when you take cases into the courts, that you're arguing the right, using the right arguments, because you don't want to cloud or create fog for all of the good work that Dr. Keanu Sai and Attorney General Dexter Kayama has done. Okay, so that you don't jump all over the place. With that, I'd like to thank all of you again for joining me tonight. And again, a big mahalo to Lynn Cox. She always makes us look really good, and everything that you see here on the Kanaka Express. Mahalo, Lynn. And until next week, please join us because I will have another really good guest that will be coming on. Ahui ho.
Uama ke ao kaina I ka pono o Hawaii Uama ke ao kaina I ka pono